134, the state of Ohio versus Noah Bays.
I feel very fortunate to be here today. I am the maternal grandmother of Noah's 13-year-old daughter. I have known Noah for approximately 15 years. His daughter has lived in my home her entire life, and I have had primary custody of her since she was 9 months old, and Noah had weekend visitation. In May of 2025, he filed for custody of my granddaughter. She did not want to live with him, and I did not feel it was in her best interest to do so. We had several hearings on the custody case, and this incident occurred 9 days prior to the day that we were set to have our trial in juvenile court. I believe that he had every intention of killing me that day. It was the most terrifying experience of my life. I think about it every day. It has changed the way I think and the sense of safety I once had. It is impossible to fully explain what it feels like to know that you came within inches of losing your life at the hands of someone you had known for so long and once trusted. The shot that hit me in the leg was very painful. It was difficult to walk, and I couldn't bend my knee for several weeks. My vehicle was destroyed. It took 3 months for me to replace it. And during that time, I had to figure out how to get to and from work and anywhere else I needed to go. This trauma has not only affected me, but my entire family. It has caused a tremendous amount of fear, stress, and emotional strain. I respectfully ask the court to impose a sentence that reflects the seriousness of the crime, recognize the damage that he has caused, and protects the community from future harm. Thank you.
Thank you.
Your Honor, Ms. Noble was not able to come today because she indicated that it created too much anxiety for her to be here and to address the court, to kind of go through this situation again. But she did state to our office that she believed that you would do the right thing. So I think what I want to address right out of the gate is the absurdity of some of the statements in the letter that the defendant submitted to you. In the letter, the defendant stated, and I quote, "I have no recollection of these things and would never do them in my right mind, no matter how angry or mad I was at someone. I am far from a violent person, even when angry." End quote. Think about that for a second. He wants you to believe that despite all of the planning and preparation that went into that day, he can't remember any of it because he was not in his, quote, right mind. Your Honor, the facts of that day demonstrate that that statement is a complete and total lie. This is someone who got up that morning and called off work so that he could specifically carry out this shooting. He then put on all black clothing and loaded his assault rifle into his car in a way that he would not be detected by the camera at the front of the house. He then drove over 50 miles from his residence in Piqua to Wayne Township to carry out this shooting. This shows the distance and time that he traveled to come all the way here to carry out this violent attack. When he arrived in Wayne Township, he concealed himself down a long lane and hid in a tree line for over 20 minutes while he waited for Emily Bear to pass through that intersection. And the reason that he knew Emily would be traveling through that specific intersection is because he had looked at the Life 360 app on his daughter's phone in the days leading up to this shooting, which showed that Emily went home every day during her lunch hour. Once Emily entered the intersection, he fired multiple rounds from his rifle, repeatedly striking her vehicle. Look at that firearm, Your Honor. Look at the ammunition that he was using. And now look at the location of the bullets on Emily Bear's vehicle. All over the doorway. Your Honor, these were all intended headshots. He was not intending to injure Emily Bear on that day. Rather, he was intending to kill her. After striking and injuring Ms. Bear, the defendant continued firing and struck the vehicle directly behind Ms. Bear, which was driven by Ms. Noble, causing her injury as well. To this day, she still has a bullet in her body. Additionally, We know that one of the bullets struck Mr. Piper's house across the street, putting the occupants of that home in danger as well. The defendant then drove all the way back to Piqua, dropped off the firearm back in his bedroom, again without being detected by the camera at the front of the house, changed his clothes, and then went to the local speedway to buy cigarettes. When he returned to his residence and was apprehended by the police, he immediately began lying, claiming that he had been home all day other than his quick trip to Speedway. When he was interviewed by detectives later that evening, he continued to lie, claiming that he was only gone from the house that day for about 10 minutes, and he further told them that the only gun he owned was a shotgun that was used for trap shooting. Think about all of the actions that the defendant took that day, the planning and preparation to carry out this shooting, and the efforts he took to cover up his actions. And now he wants you to believe that he doesn't remember anything about that day. And remember, he's not claiming that he was intoxicated or that he was high. He was perfectly sober. He just wants you to believe that for some mysterious reason, he has no recollection of that day at all. That's absurd. What he's really trying to do, Your Honor, is to get credit for accepting responsibility by entering a no contest plea while still professing and hoping that you will believe that someone like him would never commit such a violent attack if he was only in his right state of mind. What a coward. If you're going to accept responsibility for something, own it. Don't try to hide behind this phony nonsense about not being able to remember when there is zero evidence that you were under the influence or suffering a mental break. What's even more surprising in the sentencing memorandum offered by the defendant is the assertion that he did not have any concerns for his child's safety when she was with Emily Bear, and that Emily consistently provided a loving and stable home for his daughter. So that means that he was willing to kill someone who had voluntarily raised his daughter from birth and only showed her love and affection. And think about what this would have meant for his daughter if his plan had actually worked. If the defendant was successful, and if things had gone perfectly that day for him, he would have gotten away with murder, and his daughter would have always been left to wonder why her grandmother, her primary caretaker and provider, was gunned down in the middle of an intersection for no apparent reason. That was the defendant's preferred outcome for that day. One of the last things that I would point out is that the factors that the defendant highlights in his sentencing memorandum, demonstrating why he should receive a more lenient sentence, actually makes him all the more dangerous. No one saw this coming. Even Emily, when she was asked shortly after the shooting whether the defendant could have been involved, stated that she did not think that he would do something like this. The fact that there were no outward signs of anger or aggression towards Emily makes the methodical and calculated actions of the defendant all the more concerning. No one thought the defendant was capable of such a violent and senseless plot to murder someone. That's borne out in all of the letters that the court received. Only he knew what he was truly capable of, and because of that, he almost got away with it. Finally, Your Honor, there is one sentiment in the defendant's letter that I actually agree with. At the conclusion of the letter, the defendant suggested to you that 20 to 30 years in prison would not be appropriate for someone like him. And I couldn't agree more. 20 to 30 years is too light for what this defendant did. Therefore, we think a sentence in the range of 30 to 40 years is more appropriate when you consider all of the facts and circumstances and take into account that he is still being dishonest with this court with that self-serving letter he submitted, claiming to have no memory of that entire day. Thank you, Your Honor.
Thank you.
To Mr. Knippett's statements, I think they're a bit disingenuous in terms of how he's characterizing Mr. Bays' letter and all the letters in support that were provided. And part of a sentencing memorandum.
The sentencing hearing in the state of Ohio versus Noah Bay centered on a carefully planned roadside shooting that prosecutors described as an attempted execution driven by a custody dispute. And the hearing was dominated by the fear, trauma, and outrage caused by what the court viewed as a deliberate ambush. One of the first people to speak was the maternal grandmother of Noah Bay's 13-year-old daughter. She explained that she had known Noah for approximately 15 years and that his daughter had lived in her home her entire life. She had primary custody of the child since the girl was 9 months old, while Noah had weekend visitation. According to her, Noah filed for custody of the child in May 2025, but the granddaughter did not want to live with him, and the grandmother did not believe it was in the child's best interest to do so. Several hearings had already taken place in the custody matter, and the shooting occurred just 9 days before the juvenile court trial that would address the custody issue. In her statement to the court, the grandmother said she believed Noah fully intended to kill her that day. She described the shooting as the most terrifying experience of her life and said she thinks about it every day. It changed her sense of safety and the way she views the world. She told the judge that it is impossible to fully explain what it feels like to know you came within inches of losing your life at the hands of someone you had known for so long and once trusted. She also described the physical and practical consequences. A bullet struck her in the leg, causing significant pain, making it difficult to walk, and leaving her unable to bend her knee for several weeks. Her vehicle was destroyed in the attack, and it took 3 months to replace it, leaving her to struggle with transportation to work and anywhere else she needed to go. She emphasized that the trauma did not affect only her. It affected her entire family, causing tremendous fear, stress, and emotional strain. She respectfully asked the court to impose a sentence that reflected the seriousness of the crime, recognized the damage Noah had caused, and protected the community from future harm. The prosecutor then informed the court that another victim, Ms. Noble, had been unable to attend because coming to court and reliving the events caused too much anxiety. However, Ms. Noble had conveyed through the prosecutor's office that she trusted the judge to do the right thing. From there, the prosecutor turned directly to Noah Bay's letter and sentencing memorandum, attacking them as dishonest and absurd. He focused especially on Noah's statement that he had no recollection of the events and would never do something like that in his right mind, insisting that he was not a violent person even when angry. The prosecutor argued that the facts of the case completely destroyed that claim and showed instead that Noah's conduct was the result of extraordinary planning, calculation, and intent. He laid out the day of the shooting step by step to show just how much forethought went into it. According to the state, Noah got up that morning and deliberately called off work in order to carry out the shooting. He dressed in all black and loaded an assault rifle into his car in a way that would keep it hidden from the camera positioned at the front of the house. He then drove more than 50 miles from his home in Piqua to Wayne Township, specifically to commit the attack. Once there, he concealed himself down a long lane and hid in a tree line for more than 20 minutes waiting for Emily Bear to pass through the intersection he had chosen. The prosecutor said Noah knew Emily would be at that location because in the days leading up to the shooting, he had been checking the Life 360 app on his daughter's phone, which showed that Emily went home during lunch every day. This was not a spontaneous confrontation or a reckless outburst. It was a methodical ambush. The prosecutor described what happened when Emily Bear finally entered the intersection. Noah fired multiple rounds from his rifle and repeatedly struck her vehicle. The prosecutor urged the court to consider the firearm, the type of ammunition used, and the location of the bullet holes on Emily's vehicle, especially around the doorway area, arguing that these were intended headshots and that Noah was not merely trying to scare or wound her. He was trying to kill her. After striking Emily Bear, Noah continued firing and hit the vehicle directly behind hers, which was being driven by Ms. Noble. Ms. Noble was injured and, according to the prosecutor, still had a bullet in her body at the time of sentencing. The danger extended even further. One of the bullets also struck the house of Mr. Piper across the street, putting the people inside that home at risk as well. The prosecutor's narrative painted a picture of a defendant who was not only willing to murder someone he knew, but willing to unleash rifle fire in a public area where multiple people could be hit. After the shooting, Noah drove all the way back to Piqua, returned the firearm to his bedroom in a way that again avoided detection by the house camera, changed his clothes, and then went to a local speedway to buy cigarettes. The prosecutor used this detail to emphasize how calm and deliberate Noah remained after the attack. When police arrived and apprehended him, he immediately lied and claimed that he had been home all day except for a quick trip to Speedway. Later, when detectives interviewed him, he continued lying, claiming he had only been gone from the house for about 10 minutes, and even falsely stating that the only gun he owned was a shotgun used for trap shooting. In the state's view, every one of these steps, calling off work, dressing in black, hiding the rifle from the camera, driving 50 miles, waiting in concealment, firing multiple rounds, returning the gun, changing clothes, and lying to police, proved not only premeditation, but also consciousness of guilt and a deliberate cover-up.